Welcome back to Autism Live. We are welcoming back to the show Bonnie Yates. We've missed her. If you haven't watched, good morning, Bonnie. If you haven't watched when Bonnie's been on before, Bonnie is an amazing special education attorney. She helps us to figure out what your rights are, and you guys can write in questions. And we did have some questions, but I think we've decided that this morning what we really want to focus on is a very particular thing. But let's say this, that Bonnie is here courtesy of the law firm of Hirji and Chow. And Bonnie, tell us a little bit about Hirji and Chow and then give us your personal disclaimer.
All right. So Hirji and Chow is a 6-attorney law firm. We're located in Culver City. We do special education, regional center, disability discrimination, and higher education. Our website is www.lawyer4children.com, and our phone number is 310-391-0330, and we always offer a complimentary consultation for people in Southern California. My disclaimer is I'm answering general questions under California and federal law. You may live in a different state and you may have a different experience because of your specific facts. And if you have a case and you need to talk to an attorney, I would refer you to www.copa.net. That's a 50-state listing of attorneys who are presumed to be competent and have an interest in special education representation of clients. So with that, and starting the school year off, I wanted to talk this morning about prior written notice, because that's a goodie that parents need to know about, and they can exercise it much more frequently than I think they do.
Okay, prior written notice, which is one of those things that sounds like to parents,
yeah,
but can be, I'm assuming, be, as you said, quite a game changer. So what is prior written notice and how does it affect us?
What is prior written notice? Well, first of all, you will see it sometimes abbreviated PWN. And prior written notice is a place in federal and state law that provides for informed consent and kind of better parental participation. And what made me want to talk about it on the show is that it's one of those rights that we have that I don't think we understand well, and we don't use it. And it's very useful, and so I want to encourage everybody to start using it. So I know that you've had the experience of going to an IP meeting and talking intelligently about the need for a service for your child, or some component of an IEP, or of receiving a FAPE for your child, and the district has said no. Well, the law is that the district doesn't just get to say no and drop the subject. The district has to give you the reasons that they refused to implement the thing you requested, and the information they relied on in making the decision. So with that, I'm going to jump into prior written notice and talk a little bit about the legal framework for it. But what I'm wanting you to be thinking about is thinking back to the experiences that you've had where you feel like you asked an intelligent question and you didn't get the answer that you needed. You got to run around. So you can take a look at, you can just Google this and it'll come up and you can read it. So the statute is 34 CFR, which stands for Code of Federal Regulations, but it's abbreviated that way, 34 CFR 300.503A. And this is the definition of prior written notice. I'm going to read it to you. A district must provide parents with prior written notice whenever it proposes or refuses to initiate or change the identification, which would mean child find, evaluation, or educational placement of a child, or the provision of FAPE to the child. So there's a process that's supposed to happen when you ask for a service and they say no. And the purpose of the prior written notice statute, according to the Office of Special Education Programs, OSEP, is to allow parents to fully assess the change and respond. Districts, this is a quote, districts should use common sense when timing their prior written notice to a parent. It's best best to wait till the end of an IEP to avoid the appearance of predetermination. At the same time, the timing of the notice should be such that parents have enough time to assess the change and voice their objections. So if a district comes into an IEP meeting and they give you prior written notice before the meeting is over, the concern would be that they've already made up their mind, and so it's not really a discussion, it's really predetermination. With that said, if you request stuff at the IEP and they say yes or they say no, they're supposed to give you prior written notice if there's a disagreement. And they can give it at the end of the IEP and satisfy the requirements, but they have to not just say no, they have to say yes or no, and here's why, and here's the information we relied on in saying yes or no to whatever you proposed. So the prior written notice has to contain the following elements. 1, a description of what is proposed or refused, an explanation of why the agency made the decision, a description of each evaluation procedure, record, or report on which the district relied for the decision, the giving of the parents their procedural safeguards at the same time as giving them the prior written notice, sources for assistance to resolve the problem, options considered and reasons for rejecting others, and a description of other relevant factors in making the decision. And if you want to look at that section or use it as the basis of writing a letter, you can just Google California Education Code 56500.4b. The notice must be given within a reasonable time before a change of placement or a provision of FAPE, and that's again back to that 34 CFR 300-503A. That's the federal law. Districts are required to consider parent preferences. The idea does not require a school district to accept parents' choice of program, but it must consider suitable alternatives and try to reach consensus. But ultimately, if that doesn't happen, it's up to the district to offer FAPE, and they have to do so, but also give the prior written notice. So let me just talk about a couple cases, Shannon, and then we could talk about your thoughts about all this.
Okay. We've got we've got a little less than 5 minutes.
We're good. So in Portland School District, I can't read my citation. Portland School District was a case in the Ninth Circuit, which includes California, Oregon, and Washington and Hawaii. The district repeatedly refused to evaluate a 7-year-old student with sensory processing disorder in order to determine if they had dyslexia, dysgraphia, etc., and that violated the IDA. Training was ordered to the entire staff about how to process these kind of requests for evaluation. If you're going to not evaluate, you have to give prior written notice. And what they did is they just said the school psychologist is out. She won't be back till later this year, so we can't do the evaluation. And that lack of a straight answer was violative of the IDEA. You can give the notice verbally, but it has to be very specific. That's discussed in the Union School District versus Smith. You have to give it in the native language of the parent. And if the proposed change modifies an offer to the child, that's a change in placement, so you have to give prior written notice. It has to be a permanent change, though. So if it's just like speech therapist is out for 2 weeks and you're going to get comp time later, that wouldn't trigger the notice requirement. There's no requirement that they give you prior written notice as to their methodology. But the methodology, if it's written in the IEP and they propose to change it, let's say you're receiving ABA services and they propose to change it, that would probably trigger the requirement of prior written notice. I also think you can ask for prior written notice if they won't discuss the research basis on which they relied in making a service offer. I think you can ask for prior written notice in attempting to determine whether their RSP services or whatever service they offered was based on research or not. So the prior written notice must provide sufficient detail to allow the student or parent to participate in the IEP in an informed way. That's the purpose of this. So while the district isn't locked into the prior written notice it gives and it can change it at the next IEP, the idea is that within a reasonable time frame, the parents would get an answer to what they consider to be issues that are outstanding or unresolved, or if the district is proposing a change that the parents think is wrong, this gives them a way to have a discussion about it that's meaningful. And so I think when we're all reflecting on this, everybody's going to be a little surprised because we've all been victim to they say no, we, go deer in the headlights on the whole situation, and we never come back and ask them to justify their decision.
Well, and we've only got a minute and a half now, but so I want to know, because how many years have I been in this, and how many IEPs have I been to where they said no to me, and I didn't know, and I've never seen a prior written notice as you described it in the criteria. So for our parents watching who have not gotten prior written notice, what happens when you didn't get it? Do you request it, or?
You can. We do. And it's also potentially a violation of FAPE. It's a FAPE violation.
And so then you go to due process.
Yeah, and the argument would be we didn't get prior written notice on this important issue, and it's a denial of parental participation and a denial of FAPE. When we do get these letters, and certain districts do detailed versions of them, I mean, I'm sure they hate them because it takes them several pages to actually articulate this.
Yeah.
But certain districts are doing them, and I think that's because they've gotten knuckle-wrapped for it.
Yeah.
What I'm going to try to do between now and next week is I'm going to send you a sanitized prior written notice.
Okay.
So that you can see what one of these should look like.
All right.
Or could look like.
All right.
All right?
We will look forward to that.
And next week, we are going to talk about private school placements, because that seems to be going on so much now in Southern California.
All right, we will do that. Bonnie, we thank you so much, and we're so glad that you're back, and thrilled to have you back. Tk you so much for being, and please say the website again for Hear Ji and Chow.
Oh yeah, www.lawyer4children.com. I look forward to your questions and to talking with all of you next week.
Thank you so much, Bonnie. Bye-bye.
Bye, Shannon.
Hey, thanks for watching Autism Live. To subscribe, click here. And if you'd like to check out some more of our videos, click here.